As Minister with responsibility for international trade, industry and commerce, I rise with your leave, Mr. Speaker, for the third time in this House to make a brief statement on the trade-related case that has been filed by the government of Belize against the government of St. Kitts and Nevis regarding the importation of brown sugar from 2 non-CARICOM member states. After being officially notified of this matter by the Solicitor General, Mrs. Simone Bullen Thompson, on Monday, October 5th, 2020, I would have received from the SG at that time the e-filed originating application and notice of service that was sent by the Deputy Registrar and Marshal of the Caribbean Court of Justice. The claim had been filed on September 30th by the State of Belize against the Federation of St. Kitts and Nevis and the Republic of Trinidad and Tobago, with the intention of commencing proceedings against these two countries pursuant to 1, Article 211, Section 1, Subsection A, 213 and 216 of the revised Treaty of Chaguaramas, and also Article 13A and B and CVI of the Agreement establishing the Caribbean Court of Justice, and Part 10 of the CCJ Originating Jurisdiction Rule 2019. I would have first notified this Honorable House of the lawsuit on October 13, 2020, during a sitting. At that sitting, I would have informed the House of the background of the case in which St. Kitts and Nevis had been accused by Belize, along with Trinidad and Tobago, of importing sugar from Guatemala and Honduras without the application of the common external tariff known as the CT to those goods. In other words, the state of Belize was alleging that St. Kitts and Nevis had allowed these imports from Guatemala and Honduras to occur without the necessary taxes being paid, as befitting goods that are not produced in CARICOM. The period in question was November 2018 to June of 2020, during which time Belize had alleged that our federation had imported some 975 metric tons of such sugar imported from Guatemala and Honduras free of duty. Mr. Speaker, at this point, I again wish to remind the House of several key facts which we should consistently bear in mind on this matter. 1. The government of St. Kitts and Nevis does not import sugar into the Federation. Any importation of sugar by government would have been brought to an end in 2014 when the supply office was closed. 2. The state of Belize can never dictate to the people of St. Kitts and Nevis the countries from which we can or cannot import sugar. Number 3, all sugar imports into the Federation would have been based on trading arrangements being entered into by the private sector, that is, local wholesalers and retailers and overseas suppliers. Next, all goods entering the country must be processed by the Customs and Excise Department, whose staff are well trained to process these goods on the trading arrangements that are currently in place. In this particular case, customs officers are trained to know that any imports of goods coming from a non-CARICOM jurisdiction must attract the necessary duties and taxes, which are typically not applied to goods that originate in other CARICOM states. As such, all sugar imports from Guatemala and Honduras or wherever should be treated as non-CARICOM goods, and therefore should attract the common external tariff in order for the local importers to clear them out of customs. Next, the state of Belize has never ever made contact with the government of St. Kitts to indicate that there was a trade dispute between their country and ours. Also, by extension, Mr. Speaker, the allegations being made against St. Kitts and Nevis by Belize had never been placed on the agenda of CARICOM's Council on Trade and Economic Development, COTED, at any point in time, and particularly not during the period when St. Kitts and Nevis was being accused of rendering CARICOM treatment to non-CARICOM imports, that is, November 2018 to June of 2020. I remind the House that COTED is the CARICOM body that regulates and establishes policies with regards to issues of trade and development in the region. As such, it stands to reason then, Mr. Speaker, that if any member state of CARICOM has a trade dispute with another member state, then COTED should be the second place where such a dispute should be registered. Of course, I say this based on my own limited knowledge of international trade matters, meaning that if Belize had a trade dispute with St. Kitts and Nevis that they wish to settle, the first place Belize should have come to should have been this Federation of St. Kitts and Nevis, the source of their discontent. Had such a strategy been taken, I am pretty certain that there may not have been the need to seek redress at the level of the CCJ. CARICOM, I should note, was also named by Belize as a co-defendant in that case. The source of the evidence, as presented by Belize, appeared to have been simply an online database which the government of Guatemala had been publicizing. There appeared to have been no evidence on the part of Belize that we could tell to ascertain whether this information source was accurate and trustworthy before the decision was made to file the suit against the Federation. As a means of filing a comprehensive defense to the case, I would have instructed the Director of Trade, Mr. Sean Lawrence, to conduct an investigation with the Customs and Excise Department in terms of gathering data on all imports of sugar over the past 3 years. The Ministry would have subsequently received information from Customs and by extension the Ministry of Finance, to whom they report, and that information garnered revealed that St. Kitts and Nevis were in fact importing brown sugar from Honduras and Guatemala free of the application of the CET since 2014 after the supply office closed. When pressed into answering who would have authorized the illegal practice, senior management in Customs would have informed me that their actions were based on a verbal directive which the Customs Department would have received from the Office of the Prime Minister in 2014. On December 16, 2020, Mr. Speaker, during my presentation on the 2021 budgetary allocations, I would have used the opportunity once again to update the House on the status of the case filed by Belize against St. Kitts and Nevis. At that sitting, I would have confirmed that St. Kitts and Nevis was definitely at fault for non-application of the CET at the rate of 40% for imports of brown sugar originating outside of CARICOM. The source countries for the sugar were indeed Guatemala and Honduras. Upon discovering this liability, the government of St. Kitts and Nevis would have written to the government of Belize to begin negotiations geared towards removing the case from the CCJ and settle it amicably between the parties. The key features that we would have committed to in that request included A, immediate reapplication of the CET on all non-CARICOM sugar imports at the established rate of 40%, and B, settlement on terms of reference insofar as the implementation of a monitoring mechanism that ensures that there will be no future suspension of the CET on non-CARICOM brown sugar unless done with justification via the appropriate derogation application to the CARICOM Secretariat and COTED as per the provisions of the revised Treaty of Chaguaramas. I'm happy to report at this point, Mr. Speaker, that through much diplomacy and negotiations on the part of the Attorney General's chambers and the Office of the Solicitor General in particular, St. Kitts and Nevis has been successful in having the government of Belize, through its Ministry of International Trade, withdraw the case from the CCJ. I am equally pleased to report that this discontinuance and out-of-court settlement were ably executed without any financial burden whatsoever on the government and taxpayers of St. Kitts and Nevis. I repeat, I am happy to report that this entire matter has been settled without any financial burden whatsoever on the government and taxpayers of St. Kitts and Nevis, contrary to the local political chatter, the innuendo, and the conjecture that has surrounded the case. As proof of this settlement of the case, I have right here in my hand, Mr. Speaker, the notification of agreement to discontinue that was filed on January 21st, 2021, which will be made available to your office when I take my seat. I should point out that the documentation to which I refer was only received by the Attorney General's chambers on the 2nd of February, and as such, our government would have taken the decision not to make any type of announcement on the issue until we had the official document firmly in our possession. Mr. Speaker, I would like to inform the Honorable House that the schedule of the notification of agreement to discontinue has the following two conditions, which I quote directly from page 351 of 352 of the case file. And they read, 1. Pursuant to Part 16.2, Section 1 of the Caribbean Court of Justice, Original Jurisdiction Rules 2019, we, the solicitors of record for the claimant and the first defendant in this originating application, notify this honorable court that the parties have agreed to discontinue proceedings. And 2, pursuant to Part 16.2, Subsection 2, the parties give further notice that subject to any alteration or suspension of the CET approved pursuant to Article 83 of the revised Treaty of Chaguaramas, the first defendant will impose the common external tariff of 40% on the imports of brown sugar from extra-regional countries. Having said that, Mr. Speaker, our Team Unity government is indeed grateful that this matter has been quickly and amicably settled. We sincerely trust that our government will never be placed in such a precarious situation again as a result of clear violations of the terms of the revised Treaty of Chaguaramas. Our government appreciates the open-mindedness of the government of Belize in agreeing to remove the case from the CCJ and in also agreeing to settle the matter without compensation of any sort to the government of Belize. Our Ministry of International Trade owes a sincere debt of gratitude to the Solicitor General, Mrs. Simone Bullen Thompson, and Attorney General, the Honorable Vincent Byron, for the swift, professional, and astute manner in which this matter has been disposed of within just 4 short months. In closing, Mr. Speaker, I am pleased to announce the following. 1, there will be a meeting of COTED tomorrow, Friday, February 19th, for the express purpose of finalizing the draft terms of reference that outline the mechanism by which sugar imports in the region are to be monitored. And the second thing I would like to indicate is that I am confirming that St. Kitts and Nevis has reinstituted the application of the common external tariff at 40% on non-CARICOM brown sugar imports. May it please you, Mr. Speaker.